and Tobago.
Mr. Stevens, Mr. Poole, Mr. Sipsad, Mr. Middleton, good morning. Lord Hamblin, unfortunately, has to quarantine, so he'll take part in the proceedings remotely. If you could bear with us for a moment, we'll just check that all the computers are set up.
Thank you very much.
Mr. Stevens.
My Lords, as you know, I appear for the appellant with Mr. Tom Poole, QC, and the respondent is represented by Mr. Mark Sipsad and Mr. Joe Middleton, Mr. Sipsad appearing remotely. My Lords, the central issues raised by this appeal concern the following. First, the nature of the exercise in which the court is engaged when it commutes a death sentence under Section 14 of the Constitution of Trinidad and Tobago. And secondly, whether it is appropriate when commuting a death sentence in exercise of the power given under Section 14 of the Constitution on Pratt and Morgan grounds, or on account of the expectation created by the decision in Rudal and the State, which was then addressed in Matthew, to substitute a sentence other than life imprisonment. My Lords,
Mr. Stevens, it would help me at some point if you could assist us as to what precisely is meant by a life sentence in Trinidad and Tobago, yes, as a matter of law and as a matter of practice.
Well, my Lord, I was going to come to that, but a little down the road, if I may.
That's fine. I don't want to take you out of order.
Not least, my Lord, I may as well mention this at this point, because it is dealt with at some length by Lord Hughes in his judgment in Lendor at paragraphs 44, I think, or 45 to 49, but I'll come back to it.
Thank you.
My Lords, the respondent's application for constitutional relief effectively put his case on both of the two bases. So he relied on the principle established in Pratt and Morgan, inasmuch as more than 5 years had passed since he was sentenced to death, and he relied on Rudal, which effectively, which did decide that the death penalty was discretionary before it was subsequently overruled in Matthew. And he relied on that on the basis that following the decision in Rudal, he expected to be brought before the court for sentencing on the basis that it was a discretionary sentence. That expectation was addressed by the board in Matthew when it overruled Rudal, and in effect what was said in Matthew was that Pratt and Morgan would apply to those under sentence of death at the date of the judgment in Matthew because of the expectation engendered in Rudal, so anyone in that position would, as was Matthew, be entitled to commutation, having thought that they were the beneficiary of Rudal, but then having that frustrated in Matthew. And it may just be helpful. I appreciate that the board may be familiar with it, and some of the board may have had a look at it during the hearing in Chandler, but it may be helpful just to look very briefly at Matthew so that that point is clear. Matthew is...
Yes, so that I'm clear about this, there were two independent grounds for commutation then?
Well, effectively, yes, but they really come to the same thing. I mean, perhaps if you look at the record, my Lord, at page 13, it's the affidavit of Mr. Boodram. You'll see at electronic bundle, page 13, that in paragraph 5, he says there's been inordinate delay. And then at 6, by virtue of inter alia, the aforementioned inordinate delay and the mental anguish suffered, it would now constitute cruel and unusual treatment and or punishment to execute the applicant. That's effectively a classic Pratt and Morgan complaint. So that's the reliance on Pratt and Morgan's simpliciter.
And he'd already been on death row for more than 5 years.
As at the date of this application, yes.
Certainly, but he'd been more than 5 years as at the date of the Rudolph decision.
Yes, he had. Yes. The chronology is that he was convicted and sentenced on the 27th of November 1996. The 5-year, what I'll call presumptive period in Pratt & Morgan, therefore expired on the 27th of November 2001. Rudal was decided on the 20th of November 2003. Matthew was decided on the 7th of July 2004. And all of that had happened before he made his application.
Thank you.
Now, my Lord, I was just going to say that it might just be helpful to look briefly at Matthew, which is at electronic bundle 829. Just to see what the board said in Matthew. If we could start at 848, at paragraph 30. And that is the decision that the death penalty was indeed mandatory and Rudal was wrong. That nevertheless leaves a serious problem. The appellant in this appeal, Mr. Matthew, was given to understand in consequence of Rudal's case that the question of whether he should be sentenced to death would now be considered by a judge. Mr. Rudal himself is no doubt awaiting a similar hearing, and there may be others in the same position. So the appellant would have been, the respondent would have been one such other. But the effect of their lordships' decision today is that a judge would have no discretion to change a death sentence which has already been imposed according to law. Such a resentencing cannot, therefore, take place. If we then go to the top of the next page, 3 lines down under letter A, there is an analogy with Pratt. In that case, the board said at page 33 that while the death penalty itself was not inhuman punishment, to execute these men now, after holding them in an agony of suspense for so many years, would be. The same is true of executing them after informing them, at the time correctly, that the law would give them the opportunity to persuade a judge to impose a lesser sentence and then denying them that opportunity. In Pratt's case, their lordships exercised the power vested in the Supreme Court of Jamaica by Section 25(2) of the Constitution to make such orders, etc., by allowing the appeal and commuting the death sentence to life imprisonment. There is a similar power in Section 14(2) of the Constitution of Trinidad and Tobago. Pursuant to this power, their lordships will allow the appeal, set aside the sentence of death, and impose a sentence of life imprisonment. And then at 33, the next 2 lines, in their lordships' opinion, the same considerations apply to anyone else sentenced to death awaiting execution at the date of this judgment. So, in other words, the position in which the respondent was such that he could complain on classic Pratt & Morgan grounds, but also on the basis that he, after Rudal, had an expectation of a resentencing hearing. That was obviously frustrated when Rudal was overturned by Matthew. In Matthew, they dealt with the position of people such as him, and some of those people would not have already got to the 5-year point by saying, effectively, that Pratt & Morgan should apply, and those people, too, should be entitled to commutation by analogy with Pratt & Morgan. And again, the sentence that was imposed in Matthew was life imprisonment. So that's the context, my lords, in which this comes before you. Now, in the appellant's respectful submission, the critical starting point is to consider what exactly Pratt & Morgan decided, and specifically how both in that case and subsequent cases, which I will show you, the constitutional breach has been characterized. So can I take you immediately to Pratt & Morgan, which is at 933 of the electronic bundle. I'm not giving tab numbers. I don't think any of the board are using the paper. No.
We don't. They don't exist.
Oh, well,
as far as
well, you'd be hard-pressed to use them. Well, my lords, I certainly won't give you the tab numbers. So, Pratt & Morgan is at E933 now. In Pratt & Morgan, it was proposed to carry out the executions after a delay of 14 years, following the reading of 3rd death warrants in each of the 2 appellants' cases. By the time their appeals came before the board in Pratt & Morgan, they'd been in custody for 16 years. Allowing the appellant's appeals, the Board of Seven held, first, that to carry out the executions after such a period would constitute inhuman punishment contrary to Section 17(1) of the Jamaican Constitution, and also held that in any case in which execution was to take place more than 5 years after sentence, there would be strong grounds for believing that the delay was such as to constitute inhuman or degrading punishment or other treatment. Now, can I just take you briefly to a couple of passages in the judgment? First, at 961, under letter E. Their lordships will therefore depart from...
Sorry, page?
961,
Thank you very much.
At letter E, their lordships will therefore depart from Riley and hold that Section 17(2) is confined to authorising descriptions of punishment for which the court may pass sentence and does not prevent the appellant from arguing that the circumstances in which the executive intend to carry out a sentence are in breach of Section 17(1). The Court of Appeal rightly held that they were bound by the majority in Riley and did not therefore consider whether the applicants had been subjected to inhuman or degrading punishment or treatment within the meaning of Section 17(1). It is, however, to this question, which is central to this appeal, that their lordships must now turn. There is an instinctive revulsion against the prospect of hanging a man after he has been held under sentence of death for many years. What gives rise to this instinctive revulsion? The answer can only be our humanity, regarded as inhuman, an inhuman act to keep a man facing the agony of execution over a long extended period. And then, my lords, could I just briefly take you also to page 965, at letter E, where one finds that their lordships can have no doubt that an execution would now be an infringement of Section 17(1) of the Jamaican Constitution. To execute these men now after holding them in custody in an agony of suspense for so many years would be inhuman punishment within the meaning of Section 17(1). Now, from both those passages and the other cases I'll show you also address this point, what is clear in my submission is that it is the execution of a person sentenced to death after a period of long delay in which that person is held in custody in what Lord Griffiths termed an agony of suspense, which amounts to, or would amount to, inhuman punishment. So it's the execution after a long period of delay. And it's in those circumstances that the state forfeits the right to execute because of the delay, and the condemned man is spared what would otherwise amount to an unconstitutional punishment because it would be carried out after the period of delay. Now, I should also just draw your lordship's attention to a passage particularly relied on by the respondent whilst we're at the report. It's at the top of the following page, 966. Just after setting out the terms of Section 25(2), the board said this: the width of the language of the subsection enables the court to substitute for the sentence of death such order as it considers appropriate. The appropriate order in the present case is that the sentence of death of each applicant should be commuted to life imprisonment. Now, after that, my lords, the board made a number of general observations, starting immediately below that at 966.
And the language of the Jamaican provision is identical to the provision that we're considering?
Yes.
Almost.
I hesitate.
Almost identical.
For material purposes, yes. Yes. So, my lord, at 966, below that passage I've just read to you, the board then made a number of general observations and offered guidance to the Jamaican authorities. If I could just read you at 966B, their lordships are very conscious that many other prisoners under sentence of death are awaiting the outcome of the appeal. In an attempt to assist the Jamaican authorities who may be faced with a large number of appeals, their lordships wish to make some general observations. There are then observations made, including in relation to the periods within which the authority should aim to complete the criminal procedure, and so on, concluding at the bottom of that page with the expectation that it should be possible to complete the domestic appeal process within 2 years, and so on. And then, if I could ask you just to look at page 967, starting at letter F. It therefore appears to their lordships that provided there is in future no unacceptable delay in the domestic proceedings, complaints to the UNHRC from Jamaica should be infrequent, and when they do occur, it should be possible for the committee to dispose of them within reasonable dispatch, and at most within 18 months. These considerations lead their lordships to the conclusion that in any case in which execution is to take place more than 5 years after the sentence, there will be strong grounds for believing that the delay is such as to constitute inhuman or degrading punishment or other treatment. If, therefore, rather than waiting for all those prisoners who have been on death row under sentence of death for 5 years or more to commence proceedings pursuant to Section 25 of the Constitution, the Governor-General now refers all such cases to the JPC. That's the Jamaican Privy Council who administer or who play a part in the administration of the prerogative of mercy, who, in accordance with the guidance contained in this advice, recommend commutation to life imprisonment. Substantial justice will be achieved swiftly and without provoking a flood of applications to the Supreme Court for constitutional relief pursuant to Section 17(1). Now, two things are clear from those general observations in my submission. First, that the board was considering the position of all prisoners under sentence of death who had been sentenced more than 5 years previously. And secondly, that the board considered that the substitution of life sentences would be appropriate in all such cases, with the express purpose of avoiding the need for all of those prisoners to bring constitutional proceedings for redress. My Lords, that's all I'd like to say about Pratt. Could I next ask you to look, please, at the case of Guerra, which is at 200. Is it 200? No, 700 of the electronic bundle, forgive me. Now, I'll only mention Guerra briefly. It was decided in 1995. I mention it because it's the case in which the question arose as to whether the principles established in Pratt and Morgan applied in Trinidad and Tobago. If I could ask you to look at page 710, please. The last 2 lines on the page. The following issues were the subject of submissions to their lordships. 1, whether the lapse of 4 years and 10 months between the 18th of May 1989, when the applicant was convicted and sentenced, and 21st of March, when the applicant's petition for special leave to the Privy Council was dismissed, had the effect that the execution of the applicant would have been in breach of his general constitutional rights on the principle established in Pratt. And then, after referring to the decision in Pratt, and at 7...
I'm sorry, I've got a problem.
So, my Lords, at 711.
Yes, right.
At 711, the board in Guerra referred to the decision in Pratt, yes. And then at 712 went on to hold that the provisions, that the principle, in Pratt applied in the same way in Trinidad and Tobago as it did in Jamaica, and we see that at 712, starting at letter G. However, it was recognised by the Privy Council in Pratt, applying the common law, the judges of Jamaica would have had power to stay a long-delayed execution as not being in accordance with due process of law. Their lordships have no doubt that the same is true of the judges of Trinidad and Tobago, and that such execution, if not stayed, would constitute cruel and unusual punishment, with the effect that not only would any attempt by Parliament to authorise it be contrary to Section 5(2)(b) of the Constitution, but also that on the principle stated by Lord Diplock in Thornhill, such execution would not be in accordance with the due process of law under Section 4A of the Constitution, which recognises the right of the individual to life, and the right not to be deprived thereof except by due process of law. For these reasons, their lordships conclude that the principles stated in Pratt are applicable in Trinidad and Tobago as they are in Jamaica, the only difference, which is of no importance, being that in Jamaica, such execution would constitute inhuman punishment, whereas in Trinidad and Tobago it would constitute cruel and unusual punishment. So, my lords, just before putting Guerra to one side, perhaps for completeness, I should just show you two further passages which address the 5-year period. First at 717, between letters G and H at the foot of the page, it is to be observed that this period was not specified as a time limit. Its function was to enable the Jamaican authorities to deal expeditiously with the substantial number of prisoners who'd spent many years on death row, without having to deal with all such prisoners individually following constitutional proceedings. It follows that the period of 5 years was not intended to provide a limit or a yardstick by reference to which individual cases should be considered in constitutional proceedings. And then, my lord, at 718, at letter G, just below letter G, bearing in mind that the unjustified period of delay runs into a period of years and has led to a lapse of time since sentence of death was imposed far in excess of the target periods of 12 months and 2 years, and indeed close to the period 5 years from which it may be inferred without detailed examination of the particular case that there has been such delay as will render the condemned man's execution thereafter unlawful. Their lordships have no doubt that to execute the applicant after such a period of time would constitute cruel and unusual punishment, contrary to his rights under sections 4A and 52B of the Constitution. So, my lords, the 5-year period is neither a limit nor a yardstick to which individual cases should be subjected for consideration, but rather a period after the lapse of which it can be inferred or presumed that execution would be unlawful. My lords, the next case is Henfield, which is at 724 of the electronic bundle.
724.
724. And that was a case from the Bahamas, decided the following year in 1996. And in that case, again, the principles in Pratt and Morgan were considered. Could I just ask you to go to page 730, under the heading Applicable Principles, Lord Gough, giving the judgment of the board, cited Pratt and Morgan, and then turning the page to page 731, quoted from Lord Griffith's judgment, and it's part of what I read to you that he quotes. And then at 732, under the heading The 5-Year Period, Lord Gough said this: the question of the effect of prolonged delay following sentence of death normally arises in the context of the domestic appellate system. In considering the effect of such delay, attention has to be concentrated on the 5-year period specified in Pratt. This period has been treated as the overall period which in ordinary circumstances must have passed, since sentence of death before it can be said that execution will constitute cruel or inhuman punishment. It has not, however, been regarded as a fixed limit applicable in all cases, but rather as a norm which may be departed from if the circumstances of the case so require. This is shown by two contrasting cases, one Guerra that I've just shown you, 4 years, I think, and 10 months, and another Reckley. So, as Lord Gough put it, my lords, the 5-year period is the overall period which in ordinary circumstances must have been passed since sentence of death before it can be said that the execution will constitute cruel and unusual punishment. The board then went on to consider the position in the Bahamas in the context of the cases before them, and held that the equivalent norm, I should just mention this, in the Bahamas was in fact 3.5 years, albeit that conclusion was in fact short-lived, because in the next case to come before the board, also from the Bahamas, namely Fisher, for reasons that don't matter for present purposes, the period of 3.5 years was held to have been reached per incuriam. So next I come to Fisher, another case from the Bahamas decided the following year in 1997, and your lordships have that at page 678 of the bundle. That was a case in which the appellant sought to argue that pre-trial detention, so not post-conviction detention, but pre-trial detention, should be taken into account for Pratt and Morgan purposes. And that was rejected by a majority for a number of reasons, including because the state of mind of the accused man is different to that of the convicted man, although the possibility that pre-trial delay might be capable of being taken into account in an exceptional case was not entirely ruled out. In the judgment of the majority, which was again delivered by Lord Gough, again Pratt and Morgan was considered. Could your lordships go to 683, please? Starting just above letter G, the principle in Pratt's case. The principle established in Pratt's case has been the subject of further consideration by the Privy Council in later cases, notably Guerra and Henfield. It is founded on the constitutional principle which in the Bahamas is enshrined in section 70, Article 17.1 of the Constitution, that no person shall be subjected to torture or to inhuman or degrading treatment or punishment. As was pointed out in Henfield's case, at page 428b, the essential question in Pratt's case was whether the execution of a man following long delay after his sentence to death can amount to inhuman punishment contrary to Article 17.1. The Privy Council held that such delay is capable of having that effect. This is because, and then there's the quotation again from Lord Griffiths that we've looked at. There are other passages in the judgment in Pratt's case which likewise make it clear that it is the inhumanity of keeping a man facing the agony of execution over a long period of time which renders his subsequent execution unlawful. Now, my lords, I then come to the last of the cases I want to show you in connection with the principle in Pratt, and that is Thomas and Baptiste, which is another case from Trinidad and Tobago. And that is at 1225 of the electronic bundle. Among other complaints in Thomas, the case considered an allegation that the prison conditions in which the two appellants were detained amounted to cruel and unusual treatment, which they argued entitled them to commutation of their death sentences. After referring to the relevant conditions at 1251 under the heading Prison Conditions, which I won't read, and explaining, if I can summarise perhaps, that among other things, the question whether they amounted to cruel and unusual punishment was a value judgment which required careful consideration of the local authorities, and the majority concluded that they would be slow to part from the careful assessment of the Court of Appeal. Then at 1252, if I could ask you to look at this, starting just under letter A, Lord Millett said this: even if the prison conditions in themselves amounted to cruel and unusual treatment, however, and so constituted an independent breach of the applicant's constitutional rights, commutation of the sentence would not be the appropriate remedy. Pratt did not establish the principle that prolonged detention prior to execution constitutes cruel and unusual treatment. It is the carrying out of the death sentence after such detention which constitutes cruel and unusual punishment. This is because of the additional cruelty over and above that inherent in the death penalty itself, involved in carrying it out after having exposed the condemned man to a long period of alternating hope and despair, It is the circumstances in which it is proposed to carry out the sentence, not the fact that it has been preceded by a long period of imprisonment, which renders it cruel and unusual. The fact that the conditions in which the condemned man has been kept prior to execution infringe his constitutional rights does not make a lawful sentence unconstitutional. And then they observe that it would be otherwise if the condemned man were to be kept in solitary confinement or shackled or flogged or tortured. One would then say enough is enough. But they observe that the present cases fall a long way short of this. Now, my lords, those are the decisions in which, in different jurisdictions, the principles in Pratt have been considered, and I hope and don't think that I've omitted any important decision. Distilling them, what is clear and can be seen from them as well as from Matthew, but in particular from Lord Gough's judgment in Henfield that I showed you, and from that passage that we've just looked at in Lord Millett's judgment in Thomas, are a number of things. First, in my submission, that there's nothing unconstitutional about the death sentence itself, subject, of course, to the challenge to the mandatory nature of the sentence in Chandler, which was heard a couple of weeks ago, and in which judgment is reserved. Secondly, that long delay may render the carrying out of the sentence unconstitutional. Thirdly, that the norm of 5 years is treated as the overall period which, in ordinary circumstances, must have passed since the sentence of death was imposed before it can be said that execution will constitute cruel and unusual punishment. That's Lord Gough in Henfield at 732, which I showed you. And fourthly, that what is cruel and unusual punishment, and therefore unconstitutional, is the carrying out of the sentence after the delay, and that's most clear from what Lord Millett said in Thomas in the passage to which I've just taken you. Now, that the focus should be on the carrying out of the sentence after the period of 5 years is unsurprising in my submission. Lord Millett in Thomas pointed to what he described as the additional cruelty over and above that inherent in the death penalty itself, involved in carrying it out after having exposed the condemned man to a long period of alternating hope and despair. But such alternating hope and despair is inherent in the death penalty, and it will be experienced by anyone sentenced to death whilst they pursue appeals and potentially petition international bodies or potentially petition for executive clemency. Such hope and despair, or agony of mind, as Lord Griffiths put it, will therefore inevitably be experienced before the point is reached, whether it's the 5-year presumptive point, or, as has been held in 1 or 2 cases, some slightly sooner point, when it becomes unconstitutional to carry out the sentence. But that, my lords, is in the nature of the lawful sentence, and not in itself in any way unconstitutional. And so, the unconstitutionality lies, as we see from those decisions, in the carrying out of the sentence after that point is reached. Now, my lords, it's against that exposition of the case law and that summary of it that we respectfully submit that the Court of Appeal erred in concluding that the exercise in which the court is engaged when considering the question of remedy in such a case is resentencing. Further erred in concluding that the substitute sentence is at large, and further erred in concluding that the exercise requires a consideration of conventional sentencing factors. First, the Court of Appeal's view that when exercising the power to commute, it is appropriate for the court to substitute a sentence other than life imprisonment is contrary to the guidance provided by the Judicial Committee in Pratt and Morgan. Secondly, the Court of Appeal's view is contrary to the established practice which has generally obtained in numerous Caribbean states, including Trinidad and Tobago, since Pratt and Morgan. And in response to that contention in our printed case, the respondent has identified only 3 cases in which a different approach has been taken in Trinidad and Tobago. And in fact, 2 of those cases which the respondent has cited, my lords, namely Sanjit Chetal, which is at EB 565, and Fazal Mohammed, which is at 868. So in both of those cases, the judge who ordered resentencing in 2008, when he delivered judgment 4 years later, after resentencing had been carried out by another judge, said he'd been wrong to order resentencing. So, my lords, the very judge who ordered the resentencing had changed his mind, but regrettably didn't give his judgment until after resentencing had been carried out. And that judgment, delivered 4 years later, is Chetal and Mohammed, which is at 572. I don't propose to take you to any of those. Moreover, the first paragraph...
Sanjit, you say, was 565?
Sanjit was at 565. Fazal Mohammed was at 868, my lord. And then Chetal and Mohammed, which is the judgment eventually delivered by the judge who'd ordered the resentencing, is at 572. The first 2 are the decisions on resentencing.
Thank you.
Now, the first paragraph of the Chief Justice's judgment also supports the appellant's position as to the position in Trinidad and Tobago, because one sees at Electronic Bundle 67 that after referring to Pratt and Morgan, the Chief Justice says this: since that decision, our courts have routinely commuted the death sentence to one of life imprisonment without the imposition of any tariff or minimum term to be served. So, my lords, for all those reasons, as I've submitted, the Court of Appeal's view is contrary to the established practice which has obtained in various Caribbean states and including Trinidad and Tobago. Thirdly...
It may be routine, but it doesn't follow that it's the inevitable or only legally available sentence.
Well, that depends on the outcome of this appeal, in part, my lord. I entirely accept the proposition that that is what has been done, and I am saying no more than that. I am not suggesting that in each or any of those cases any detailed consideration was given to the question whether there might be an alternative, which is what your lordships are asked to grapple with.
Thank you.
But nevertheless, one does have the starting position of what was said in Pratt, which was said by an expanded board and said to apply to all prisoners without any discrimination between the prisoners on death row, that they should all be commuted to life. One then has a period of 28 years during the course of which an invariable practice has been followed. I'm not submitting that anyone has raised the questions raised in this appeal during that period, but it's nevertheless a striking backdrop. And with respect to the Court of Appeal, their conclusions do fly somewhat in the face of those factors. But thirdly, and more importantly in our submission, the Court of Appeal's reasoning is flawed in several respects. And as to that, we make the following submissions. But can I just take you, before I make the submissions, to one paragraph of the Court of Appeal's judgment, namely at EB 74, paragraph 23. Which is at tab 7 of the key documents bundle, if your lordships do have that, which I think you probably do. Paragraph 23. To this end, we hold that the court, in exercising its original jurisdiction under Section 14, has the discretion to take into account normal sentencing factors on the vacating of the death sentence. The imposition of a mandatory death sentence is already in and of itself arbitrary and in violation of the Constitution and the Charter of Inter-American Human Rights, to which this country is a signatory. To be clear, although the expression judicial commutation has been used, the court, in fashioning a remedy under Section 14, is not engaged in the exercise of the prerogative of mercy. It is, in fact, resentencing the applicant in recognition of the fact that he's already been partly punished by reason of having endured the mental anguish of being on death row for an inordinately long time. The court must therefore ask itself what additional punishment, if any, would be appropriate in the particular circumstances. Now, my lords, the submissions that we make as to the way in which we respectfully suggest that the Court of Appeal's reasoning is flawed are as follows. First, the Chief Justice suggests that in the exercise of the Section 14 jurisdiction, the Court has the discretion to take into account normal sentencing factors when vacating the death sentence. That, however, is to focus on the nature of the offence and the offender, not the entirely different consideration that it would be unconstitutional to carry out the death sentence after the period of delay. And that's the first sentence of paragraph 23. Secondly, as appears from the next sentence in paragraph 23, which perhaps, with respect, explains what we submit is the first error, the Chief Justice's reasoning proceeds, or at any rate appears to proceed, on the erroneous basis that the imposition of the mandatory death penalty in Trinidad and Tobago is in violation of the Constitution. That, however, overlooks an obvious but critical point, namely that the majority in Matthew held that the effect of Section 6 of the Constitution is to render the mandatory death penalty in conformity with the Constitution, subject again to the Board's decision in Chandler, of course.
It may be that a second sentence has to be read in the light of paragraph 20.
Well, my lord,
the judgment, where it's put rather differently.
Well, my lord, that is possible, but I'm going to come to paragraph 20 in due course, if I may. The Chief Justice's error in the respect in which I'm focusing on at the moment is also plain from the next paragraph in our submission, paragraph 24. There is no logical reason why the sentence of life imprisonment should be imposed carte blanche upon every person who has their sentence commuted. That is inherently arbitrary and potentially disproportionate. The circumstances of each murder are different, and a court properly seized of the relevant facts would be able to substitute the proper sentence. But my lords, our response to that is this, that the court in a Pratt and Morgan case is not concerned with the circumstances of the particular murder, because the mandatory death sentence is lawful. The court is concerned, and concerned only, with granting an appropriate remedy in recognition of the fact that it would be unconstitutional to carry out the lawful sentence, which is a different proposition.
Does the need to consider what is an appropriate remedy not import considerations in relation to the offence and the offender?
My lord, no, in our respectful submission.
As a matter of policy, is that right?
Well, my lord,
I mean, there's no justification for the remedy would therefore be inappropriate for the particular circumstances of an individual case.
Because of the mandatory penalty.
Because of the mandatory penalty.
Yes.
And
well,
so
lord,
you seek to impose an inappropriate remedy.
My lord, no. You seek to. You mean if you go about it by way of individual sentence?
Yes.
Yes, you do.
No. An individual sentence will arrive at an appropriate sentence for the individual. But what you're seeking to do is to arrive at a sentence that is inappropriate for the individual, but appropriate based upon the statutory framework.
Well, my lord, that depends on how one considers the question of appropriateness. If one starts from the proposition that the mandatory death penalty is the law, and there is no differentiation between different types of murder, and every murderer is to be treated in the same way, then it's appropriate certainly to focus on the constitutional breach, which is the threat of execution after the period of detention on death row, after that point has been reached. But it's not appropriate in the face of the law to revisit the circumstances of the offence, because that is then tantamount to sentencing for an offence which has a discretionary sentence, not an offence that has a mandatory sentence.
So you're saying that because the mandatory death penalty is lawful and operates and is to be applied indiscriminately, that therefore whatever is substituted for it must also operate indiscriminately?
Well, my lord, one has to. Why I started with the nature of the breach is one has to look and see what it is that is infringed in a Pratt and Morgan case, and it has nothing to do with either the offence or the sentence per se. It has everything to do with the carrying out of the sentence. And so, in those circumstances, it's appropriate to treat all murderers in the same way if they're in a Pratt and Morgan situation and able to challenge the execution of the sentence, rather than to adopt some artificial process by which, contrary to the mandate of the law, you consider their case as if, wholly artificially, as if there were a discretionary sentence for murder. My lords, I'm going to develop this, but that is essentially the proposition, yes.
But if the sentence can no longer be carried out, it's necessary to decide what is appropriate in those circumstances.
Well, it's necessary to afford relief, constitutional relief, and as I'll be submitting, the appropriate relief is to alleviate the threat of execution by effectively removing the man from death row, which is the effect of the commutation, but substituting what we would submit is the next most serious sentence, which then reflects the policy of the law and the legislative intent, because there is no attack in this context, in this Pratt and Morgan context, there is no attack on the legality of the sentence or the underlying policy that informs it. The attack is only on carrying it out after a particular period has lapsed.
Well, when you get to it, you're going to have to help me, I'm afraid, on whether this is the next most severe sentence.
Well, my lord,
because there's some material that suggests that it may not be.
Well, my lord, our answer to that, I may as well try and answer that at this point. Our answer to that is simply this, that life can mean life. And in that sense, it is the next most serious sentence. It may not, because as you'll see when I take you to Lendor, Lord Hughes explains that there is a process of review, and it can result in earlier release. I understand that.
Detention at the President's pleasure, if that's the expression that's
I think it's now the court's pleasure, my lord, because
now the court's pleasure.
Yes.
Detention at the court's pleasure would also permit detention for the rest of the natural life.
Well, it could, subject to review by the court, whereas the life sentence is subject to executive review. Both could result in earlier release, or both could result in detention for the rest of the person's life. My lord, I will come back to the life sentence and assist your lordships as much as I can in that respect. Thirdly,
sorry, just to pursue the point about the death penalty being mandatory and that being in compliance with the Constitution, subject to Chandler.
Yes.
How can the state take, if you like, the benefit of that when it, by its own conduct, has disabled itself from carrying out that constitutional sentence and has to do something else?
Well, my lord,
the sentence is rendered constitutional because of the savings clause in Section 6, but once it becomes impossible to carry out that sentence, why isn't one forced back to actual application of the rights in the Constitution itself, because the savings clause doesn't apply to any new exercise that has to be carried out?
Well, because, critically, my lord, the sentence remains lawful. And we'll see Lord Hughes saying that in Lendor himself. What is no longer lawful and therefore unconstitutional is the carrying out of the sentence. So there's no attack in a Pratt and Morgan case on the sentence.
But you have to commute in order to, and then replace it with something else.
The necessary consequence of Pratt and Morgan is that it is commuted and replaced, but that doesn't mean it was an unlawful sentence.
Well, forgive me for putting it this way. So what? If it can't be carried out and the state has to take some replacement or substitution action, which isn't covered by the savings clause in Section 6, why is the state then not obliged at that point to comply with the general human rights in the Constitution? That they're not disapplied, so far as the new replacement action is concerned, by any savings clause?
My Lord, I can only repeat, I fear, that because the exercise that is being carried out is directed to alleviating the constitutional breach, there being no attack on the sentence as such. Now, what has to be done in those circumstances is appropriate relief has to be given. Now, if there's no attack and no basis for undermining the actual sentence, the appropriate relief in our submission, consistent with what has been done over the best part of 28 years since Pratt and Morgan, is to substitute the next most serious sentence, which reflects the underlying legislative policy, having alleviated the breach, which the commutation does, and that's what that is directed to.
Yes, thank you.
And that would be entirely arbitrary.
Well, no, with respect, because it's the execution after that period that is unlawful.
The relief that is imposed, or sorry, the appropriate order would be arbitrary, because it would apply across the board to every murderer, regardless of the fact that you accept that murderers differ.
Well, I accept that, of course, but it's not arbitrary if it is consistent with the undisturbed provisions of Section 4 of the Offences Against the Person Act and the legislative intent, which is that notwithstanding the violation of sections of the Constitution because of the failure to discriminate between different types of murder, all murders are constitutionally treated in the same way.
But it's not consistent with Section 4. That's what I was seeking to put to you, because you can't comply with Section 4. You have to do something else.
Well, my Lord, it respects the legislative intent behind Section 4, which is that all murderers are to be treated the same way. By substituting, in the case of all murderers who have the advantage of Pratt and Morgan, the next most serious sentence, you are reflecting that legislative intention.
Yes, I see.
That's the short answer to the point, my Lord. Whether it's right or wrong, that's the state's answer.
Yeah, thank you.
My Lord, next, the Chief Justice's analysis in paragraph 23 of the judgment in terms of the respondent having been partly punished by reason of having endured the mental anguish of being on death row for an inordinately long period, leads the Chief Justice to suggest that the question for the court is what additional punishment, if any, would be appropriate. Now, that approach, with respect, overlooks, or at any rate risks obscuring, the principle established in Pratt and Morgan in my submission, because it focuses on the period of detention during which the condemned man is on death row, rather than carrying out of the death sentence after that detention.
He says it's a mitigating factor to be taken into account when you impose a sentence, an appropriate sentence.
Well, if you're sentencing, my Lord, but that's the
But
whole...
if you are sentencing, then isn't it an appropriate factor to be taken into account?
If you are permissibly conducting a sentencing exercise, I see the force of what your Lordship is saying. Not only does that shift the focus, what we've just looked at and what the Lord Chief Justice said in paragraph 23, to the consideration of the level of suffering whilst under the sentence, to which I'll return in a moment. It's the starting point for an assessment of what additional punishment, that's the way he puts it, if any, that should be provided for. And on that basis, again, with respect, the Chief Justice is approaching the court's task as an exercise in assessing the appropriate level of punishment for the offence. It can only be that. But again, that's not the process in which the court is engaged when it is acting pursuant to Section 14 of the Constitution, when it's seeking to provide redress for a constitutional breach, which is very different to a punishment for the original offence. And there's an additional problem with focusing on the level of suffering whilst under sentence of death in my submission. Whilst that period is relevant for Pratt and Morgan purposes because execution after that period is unconstitutional, the agony of mind of a person in that position during the period following conviction and sentence, and whilst he's pursuing remedies, but before that point is reached, when the delay exceeds a reasonable period, is not a material factor, I submit, for Section 14 purposes for two reasons. First, and we jumped ahead to this, my Lord, because the sentence is lawful, and secondly, because such suffering, the agony of mind referred to by Lord Griffiths, is inherent in the lawful sentence and likely to be experienced by anyone sentenced to death. So anguish suffered before that point is reached, which is inherent in the sentence, cannot be relevant because, ex hypothesi, execution before that point is reached would not be unconstitutional despite the suffering.
I can see that such suffering may not of itself be a cruel and unusual punishment. But surely it's relevant to what sentence should be the appropriate sentence to be substituted for that which can no longer be carried out.
Well, my Lord, no in my respectful submission, because as I've just submitted, that anguish before that point is inherent in the sentence, and it can't therefore be relevant because execution before that point is constitutional despite that suffering. And what you are seeking to redress when you're giving constitutional relief is not that suffering. It is the execution after that period of suffering. That's what all the cases quite clearly, and particularly Lord Millett and Thomas that I showed you, illustrate.
Would he be entitled to damages?
My Lord, that's something that I'll touch on, if I may, at the end of my submissions, but possibly.
Right.
Possibly.
Has he claimed damages in this case?
I don't believe so. I'll be correct. No. There is one case.
But I thought you'd accepted that if sentencing, then it is an appropriate factor to be taken into account. But as I understand you now, the first 5 years you think isn't appropriate. After 5 years, you take into account the suffering, the mental anguish. Is that the argument?
My Lord, what I was going to come to, and your Lordship has presciently anticipated, is that based on my argument, one could mount an argument for constitutional relief in reliance upon suffering after the 5-year period. Yeah. And in those circumstances, for reasons that I will address, in the right case, it could potentially attract an award of damages, but it could not result, I respectfully submit, in a lesser sentence for reasons I'll come to.
Yeah.
So, my Lords, in short, to summarise what I've been saying, there's nothing unconstitutional in the suffering of itself before that point. What is or would be unconstitutional is the carrying out of the sentence after that point. And the fundamental problem, as we submit with the Court of Appeals approach, is that it confuses two things. And they're entirely different things. On the one hand, sentencing, and on the other, constitutional relief. And the error is the more acute, where there is no question but that, first, the original sentence was lawful. Second, the original sentence was mandatory, so there was no scope to consider the circumstances of the offence or the offender. And thirdly, the constitutional complaint relates not to the sentence, but to the carrying out of the sentence. And while sentencing in a case in which there is a discretion, which there is not for murder in Trinidad and Tobago, requires a focus on the particular offence and the offender, constitutional relief requires a focus on what has happened and is said to be unconstitutional. So you don't look back at the offence, because that's in no way, shape or form relevant for the purposes of the breach, which has happened later and is the result of different circumstances entirely. And with respect, the Court of Appeal failed to appreciate that difference and erred in its approach, not only at paragraph 23, but also we submit at paragraph 50, which is at 86, where the Chief Justice suggests that it's incumbent on the court to impose a sentence which is in accordance with common law principles or aims of punishment. And similarly at 51, which is at 87, where he suggests that a resentencing court must ascertain whether the punitive element of the sentence has been satisfied, and also whether the appellant has been rehabilitated and is safe for reintegration into society. Now that is classically the language of sentencing, not constitutional redress, and is particularly inapposite, we submit, where the offence is murder and the penalty mandatory, and where the constitutional complaint relates not to the offence or sentence, as I've submitted, but to the carrying out of the sentence.
Do I understand you correctly that if, in fact, it is a sentencing exercise, the Constitutional Court has the ability to refer the matter to the criminal court for resentencing? No,
I'm not sure that would be right.
And what is the effect of the order of paragraph 51? What's the effect of that? What is to be the next step?
The next step, my lord, let me just check before I answer. Yes. This started as a constitutional motion before a High Court judge, so the remission is to that judge, as I apprehend it. We actually have the order, and it's not all that helpful with respect at page 88. The matter is remitted to the first instance court with no order as to costs. What the Court of Appeal intended may be a little bit clearer from page 91 of the record. At page 89, we see that this order relates to the application for conditional leave to appeal to your lordships. And page 91, at 4, there be a stay of that part of the order which provides that the appellant claimant is to have a resentencing hearing. Now, I mean, what that makes clear is that it's to be resentencing. I should point out this is a differently constituted Court of Appeal, but the Chief Justice was nevertheless, I think, no, he wasn't. It is a completely differently constituted Court of Appeal, but nevertheless, it makes it clear that it's resentencing. It doesn't help with the question of to whom the remission was to be made or who's going to carry it out. But my understanding is that
it seems to say to the High Court.
Well, it does say to
here and determine the nature of the order to be made on such resentence.
Yes, well, my lord, it does. What I said before, I think, and what I was trying to say was that I think the remission is to the High Court judge who heard the constitutional motion, which this is consistent with, I think.
Right. And this order seems to contemplate, as perhaps one might expect, that since it's a constitutional complaint, it's the High Court that affords the relief on that constitutional complaint, and
in the form of
if the relief is by way of resentencing, it's the High Court that does the resentencing.
My lord, that's the way I reconcile paragraph 51 of the judgment, the order of the Court of Appeal and this order. It's remission to the High Court who heard the complaint, but for relief, for the reasons the Court of Appeal gave, by way of resentencing, importing the normal procedures that are required and consideration of all the normal considerations on a resentencing hearing. That's my understanding of it.
Does the High Court have original criminal jurisdiction? Was the original trial of Mr. Boodram before the High Court?
My Lord, I'll need to check that, but I believe the answer is yes. Can I revert after the lunch adjournment in relation to that?
Of course.
Sorry, I can't assist you in that.
Presumably the original criminal judge has long since retired, seeing as how 21 years.
Well, I think that's a real possibility, my Lord. I wouldn't put it higher than that.
It's 25 years.
25 years.
My Lord, so I just submitted that, with respect, the Court failed to appreciate what was two different processes. The Court of Appeal's approach in our submission would in substance be tantamount to resentencing for the original offence on a discretionary basis, despite the mandatory nature of the death penalty, and effectively thereby imposing a sentence not authorised by the law. And by that I mean Section 4 and the criminal law.
But something has to be put in place of a sentence which can no longer be carried out.
Well,
so whatever it is not going to be in accordance with the mandatory requirement of Section 4.
No, but if it's a life sentence, which is what has happened ever since Pratt and Morgan and what the board clearly thought appropriate across the board, irrespective of the type of murderers which it was addressing, that does respect, that's the way I put it, respect the legislative intent behind what was and remains a lawful sentence.
But why should that legislative intent be respected when the state has, by its own actions, lost the opportunity of having a mandatory death sentence under Section 4 implemented? And the court, as my Lord says, has to find a substitution since the death penalty ex hypothesi cannot be implemented. Well, why isn't one taken back to the general constitutional provisions? Because the savings clause doesn't apply in respect of what happens now.
Well, my Lord, the sentence has to be respected, as I've already submitted, because there is no attack, no constitutional attack on the sentence, and the sentence was and remains lawful. The state is nevertheless disentitled as a result of the relief which is granted from carrying out that sentence. And that is the appropriate relief, is the way. I'm going to come on to the question of why it's appropriate in due course, but that in that sense, the state is not able to enforce the law, but the attack being on the carrying out of the sentence, not the sentence itself, it would be inappropriate to go behind what is and remains a lawful sentence. My Lord, a long time ago you asked me about paragraph 20 of the Court of Appeal's judgment. I was about to touch on that now. I meant to earlier, I'm sorry. One can also see the error of the Court of Appeal's approach in my respectful submission in paragraph 20. So the mandatory death sentence is the law in Trinidad and Tobago, and it is within the realm of Parliament to change it. However, the courts are charged with upholding the Constitution, which is the supreme law of the land. We must resolve that tension. In effect, we have kept in place a punishment that does violence to Section 4A and 5.2b of the Constitution. And I accept that reading that, one might construe, although it is not what is said in terms in paragraph 23, that what really the Chief Justice meant, although he didn't say this, was that it's in violation of those provisions, but nevertheless lawful because it is saved. I accept that is one way of looking at paragraph 23. Have said that the delay in carrying out executions continues cruel and unusual punishment, and yet have failed to grapple with the obligation to uphold the rights and freedoms enshrined in our Constitution. Sentencing, whether by way of commutation or otherwise, is first and foremost an exercise of judicial discretion. Once it is accepted that the death sentence must be set aside, there is nothing in the language of Matthews that is inconsistent with the philosophy underpinning Rudall, where the majority remitted the matter to the trial judge to decide as a matter of discretion what sentence to impose. Now, my lords, despite recognising the mandatory nature of the death penalty, the Chief Justice suggests that we fail to grapple with the obligation to uphold the rights and freedoms enshrined in our Constitution. Presumably that is an observation in respect of the legislature. But be that as it may, from that he then reasons that sentencing, whether by commutation or otherwise, is first and foremost an exercise of judicial discretion, and that once it's recognised that the death penalty must be set aside, in other words, on Pratt and Morgan grounds, there's nothing in Matthew which is inconsistent with Rudall. Now, my lords, with respect, that is both, once again, if your lordships accept my submissions, to confuse sentencing and constitutional relief, but also to overlook the fact that whilst the majority in Rudall thought that Section 4 of the Offences Against the Person Act should be modified to provide for a discretionary sentence, Rudall was overturned in Matthew. And my lord, one gets the strong sense that the reliance placed there on the majority in Rudall is very much in the same vein as paragraph 23, and the complaint I make that the Chief Justice has effectively treated the death penalty as unconstitutional for the purpose of reasoning to the result that resentencing is appropriate, as if there were a discretionary sentence in the first place for what is an offence that attracts a mandatory penalty. Now,
can I just check? We didn't look at Rudall. Is the summary there correct that the majority, I appreciate it was overturned, they were overturned in Matthew, but the majority in Rudall remitted the matter generally for resentencing?
my lord, I think so, but I'm going to check that over the lunch adjournment as well, if I may, because it may be that more was said than that. We do have Rudall, actually. I'm sorry, I just...
It's tab 24, Mr. Stevens.
I'm most grateful, my lord, particularly for the tab number, because I'm doing this...
Page 1021.
Thank you very much.
Sorry, 1019.
Yes, my lord. The paragraph 35, I'm told, thank you. Is that... That's the majority, though, isn't it? Oh, no, it's the minority. Yes, the minorities... No, that's the majority disposal.
I think the Chief Justice is talking about the majority.
He is, my lord, yes. And yes.
Sorry,
paragraph 35 on page 1039.
Thank you.
The Privy Council quashes the mandatory sentence of death imposed on the appellant and remits the matter for the trial judge to decide as a matter of discretion what sentence to impose. Now, that's because it was an attack on the sentence. And if the sentence is unlawful, then obviously you have to go back to the trial judge for the reimposition of a discretionary sentence. So, my lords...
So that makes all the difference, you say, because it's not, in the present case, it's not an attack on the sentence which was originally lawful.
It does make the difference, my lord. I mean, there are a number of factors that I've addressed you to, but that is an important factor. There is absolutely no attack on the sentence of death for murder. And if the result of delay is to entitle someone to relief, and what is unconstitutional is the carrying out of the sentence, that is what you do something about. You don't go about treating the offence as if, in fact, it was an offence that attracted a discretionary sentence in the first place.
The language there rather suggests that the board was contemplating that it would be to the, is this right, the trial judge sitting in the criminal court?
Well, yes.
Or is it a reference to the trial in the High Court on the constitutional claim?
My lord, I think the answer to that, forgive me, my lord.
Or perhaps they're just assuming that it could be the same judge,
No.
but perhaps...
Which page is it, Tom?
Because a judge of the High Court could have been the trial judge.
Well, my lord, the Yes, my lord. Just looking at the head note,
Yep.
if I may, on page 1019, the appellant was convicted of murder and was sentenced to death under Section 4. He appealed against sentence on the principal grounds that. So this was an attack on the legality of the sentence in the context of the criminal proceedings, and therefore, clearly, the remission is to the trial judge who, because he did not appreciate that the law was wrong, imposed the death penalty when he should have considered what sentence to impose.
Surely it can't make any difference what remedies are available, depending on which route you follow.
It can and it does, because there's been two cases before the board, the first called Ramdeen and the second Hunt and Khan. And the effect of Hunt and Khan reversing Ramdeen, both with majority decisions, was to the effect that if on a criminal appeal, which comes up to the board on a petition for special leave, the board realises or is told that the 5-year period has passed, the board does not have jurisdiction to grant a constitutional remedy in that context, and regrettable though it may be, the case has to go back to a constitutional court on a motion.
That's because the board wasn't properly seized of the matter.
No, it's a question of the court's jurisdiction, my lord, and we don't have Hunt and Khan, but there's detailed consideration of it. It doesn't have original jurisdiction to grant constitutional relief unless the procedure required under Section 14 has been complied with, which is a motion, and then if it happens, an appeal to the Court of Appeal, and then by that route a constitutional matter can get to the board, at which point the board does have jurisdiction. My lord, it's Hunt and Khan, and we'll give you the reference after the lunch adjournment.
And that's different from Pratt and Morgan, which was a constitutional.
It was, and different also from Rudal, which was a criminal case, and therefore the remission would be to the trial judge because the attack was on the sentence, and he was the person who'd imposed the wrong sentence. My lord, I hope that's as clear as it can be. But
yes, as I follow what you're saying, I mean, there may be different avenues to vindicate constitutional rights. In Rudal, in fact, there was an avenue which enabled that to be done within the context of the criminal proceedings themselves. Well, that won't always be the case, and sometimes you have to go to the High Court for your constitutional relief.
Yes, I mean, it was possible in Rudal because the lack of constitutionality was said to be the sentence itself. So the criminal court was seized of that because it was the court that was sentencing. And so that challenge could, and obviously properly, had to be made to the criminal court.
Quite. I mean, that, as I understand it, reflects, if you like, the operation of the Constitution in Trinidad and Tobago, that it may be that vindication is possible in ordinary proceedings.
Maybe.
In which case, your proper course is to seek for vindication in the ordinary proceedings. The constitutional proceedings to the High Court is really a fallback if there is no appropriate procedural avenue to vindicate the constitutional rights in ordinary proceedings.
Well, yes, my lord, I only balk a little at fallback because in the vast majority of cases, claims to enforce constitutional rights are brought by motion, and that is because generally that is the way in which they are.
Certainly, but if you get it wrong, you can be told, well, it's an abuse of process to go to the High Court because you had an ordinary avenue to, within the ordinary proceedings to vindicate your rights.
Well, I suppose you could, my lord, much as you could be told in the right case that you didn't even have to have recourse to the Constitution because there was a common law remedy which you should have availed yourself of, yes.
Certainly. But that being the pattern for seeking to vindicate your constitutional rights, I mean, one wouldn't expect anything significant to attach to the fact that one procedural route is available rather than another, would you?
My lord, I'm not. Forgive me. I'm not sure I understand what you mean by significant. Significant in what respect?
In terms of the form of substantive relief that you're seeking to obtain in order to vindicate your constitutional rights.
Well, no, my lord. I mean, it all depends about It all depends on which court you're before and what you're complaining about, really. I mean, that's the short point.
Yes. Right.
It may be that you can complain to the criminal court. You certainly can if you're attacking the actual sentence, because it's part of that court's job to impose the sentence.
Yes.
If what you're complaining about is something subsequent, such as the reading of the warrant after 5 years and the threat of execution, then obviously you're not before the criminal court. No court is seized of the matter, and your route is by way of constitutional motion.
Yes. Yes, thank you.
My Lord, properly analysed, Pratt and Morgan, or a case such as the present, a Pratt and Morgan case, as I'll call it, what the court is being asked to grant redress on the basis that to execute after a period of long delay would amount to cruel and unusual punishment, whilst the remedy necessarily involves commutation of the legally prescribed sentence, death, and the substitution of a lesser sentence, we say life, and I'll come to the question of appropriateness in a moment. It is nevertheless a constitutional remedy and not a resentencing exercise. My Lord, that was by way of conclusion as to the nature of the exercise that the court is engaged in, which is...
Before we move on then, the same issue can arise as to the constitutionality in the context of a criminal appeal to the Court of Appeal of Trinidad and Tobago, or on a constitutional application.
Well, the same issue, my Lord. The question of delay in carrying out the execution couldn't arise in the context of a criminal appeal.
The issue as to what is an appropriate alternative sentence.
Well, my Lord, if the attack is on the sentence and the court finds that it is not a sentence which is lawful, then the question is, what happens next? In the context of the mandatory death sentence, the result would be, and was in Rudal, that the sentence is discretionary. If that is the position that the court is in, it can then go on and impose such other discretionary sentences as it sees fit. But the criminal court can't otherwise fashion some form of constitutional remedy. No, that is the paradigm work of the Constitutional Court and the jurisdiction under Section 14, which is not what is engaged, where a criminal court accepts that the sentence it's being asked to impose is unlawful, that it must be read as a discretionary sentence, and it therefore can and should impose some lesser sentence.
Yes, thank you.
So, my Lord, I come to the next question. What can or should the court do when commuting a death sentence on Pratt and Morgan grounds in the exercise of Section 14 of the Constitution? And, my Lords, we've strayed into some of this already, but I'll try not to delay my submissions too much by repeating what I've already said. We, of course, accept the wide powers given to the court under Section 14. Nevertheless, we make the following submissions. First, the power given to the court is to make such orders, etc., as it may consider appropriate. The redress must therefore be appropriate, and I'll come back to that point. Secondly, whilst accepting the breadth of the power under Section 14, as I've already submitted, the substitution of a life sentence in a case such as the present was clearly what was thought appropriate in Pratt and Morgan. Not only in the two appeals under consideration, but also in the cases of all other prisoners in Jamaica who at that time had been under sentence of death for 5 years or more. And I would respectfully emphasise that the Judicial Committee's order in the case of Pratt and Morgan and its observations more generally as to the position of others was the decision of an enlarged board of 7 in a case of self-evident constitutional importance. It was the consequence of fully reasoned analysis of the pre-existing position at common law, which led the court to the conclusion that it could be inhuman punishment after the period of 5 years. And the approach which was adopted in that case has not been questioned in the intervening 28, I think it is, years until this case. That's quite a striking feature, my lords. Thirdly, again, I've already touched on this, the Chief Justice himself noted that it had been routine in Trinidad and Tobago for this to happen since Pratt and Morgan had been decided, which presumably means that it was therefore considered appropriate in Trinidad and Tobago. Fourthly, and this is territory into which I've already strayed, so forgive me, the substitution of a sentence of life imprisonment both meets the gravamen of the constitutional complaint, i.e. execution after a period of long delay, by removing that threat of execution, but critically in our submission, also respects the seriousness of the offence and the clear legislative intent of Section 4 of the OAPA. Now, by seriousness of the offence, I mean the seriousness of the offence as it exists in Trinidad and Tobago. And accordingly, for those 4 reasons, and I'm going to go on to develop some of this, the only appropriate order in our submission in a Pratt and Morgan case is to substitute a life sentence. Now,
it may be when you're talking about recognising the seriousness of the offence in the context of Section 4, you're making essentially the same point that you've said already about legislative intent. But I mean, I had understood you to accept in answer to my Lord Stevens that there is a range of seriousness of murder depending on the particular circumstances of individual offences.
Well, I do accept that, and that's why even the majority in Matthew and the minority in Rudal accepted that a mandatory death sentence was inconsistent with Section 5.2b of the Constitution. But that didn't mean it was either unlawful or unconstitutional because of the effect of Section. Well, my lords, I don't want to rehearse what I argued only 2 weeks ago because of the effect of Section
The reason
6.
for my question, I just wanted to check that you weren't retreating from what you had said previously. It really, when you talk about recognising the seriousness of the offence, you're actually talking about as stated in Section 4 of the OAPA.
And my rather clumsy shorthand for that was as it exists in Trinidad and Tobago. That's
right.
That's what I meant.
I thought that's what you meant, but I wanted to check.
My lord was right, and I'm sorry I didn't make it clear.
I'm sorry to repeat the point, but the seriousness of the offence isn't being recognised because you don't distinguish between mass murderers who carry out terrorist acts and somebody who is just on the verge of diminished responsibility.
Well, my lord, no, and for that reason, the mandatory death sentence is in conflict or inconsistent with the provisions of the Constitution. But nevertheless, it does respect the seriousness of the offence as it is enacted and regarded in Trinidad and Tobago, because the legislative intent is absolutely clear. And that, putting it bluntly, but it comes to this, is that all murderers deserve to die, regardless of the actual offence which they have committed. Well, that is the starting point. And it's in that sense that it's respectful of the legislative intent.
Would, if the legislator passed an act now to say that all murderers deserve to have the same period of imprisonment or the same sentence imposed on them, would that be constitutional?
No, probably not, my lord, because it wouldn't be an existing law.
Yeah. But by a side win, that's exactly what you're seeking to achieve.
Well, no, my lord, because the original sentence has not been in any way undermined. It was lawful, it remains lawful.
Not to carry it out. I mean, how has it not been undermined if you can't carry it out?
My lord, can I just bear with me one moment, my lord? My lords have Lendor in the bundle at 758. And I will come back to Lendor, but can I just ask you to look at 766? This was a case in which there'd been executive commutation, some to life, some to 75 years, I think. And there was an attack on that for any number of reasons. But at page 766, under the heading An Entitlement to Judicial Substitution of Sentences, at paragraph 9, Lord Hughes said this. This was the substantial argument advanced by Mr. Fitzgerald before the board. On the assumption that a Pratt and Morgan case is within section 87, it ran as follows. A, the death sentence has become unlawful. B, the prisoner has become entitled as a matter of law to commutation of the death penalty and substitution of a lesser sentence. And then just dropping down to 10, this argument fails at each of these several stages. First, as to A, the original sentence has not become unlawful. It has become unlawful to carry it out. The original sentence of death was lawful. Indeed, it was mandatory. The court of trial had no choice. All that has become unlawful is carrying it out after unreasonable delay. The argument assumes that both A and B an equivalence between a sentence which was unlawful or legally erroneous when passed and one which was lawful, but which it has subsequently become unlawful to carry out. My lord, that really is encapsulating, rather more elegantly, what I've been saying, and is our submission.
Yes, I think what I was putting to you is, how is the sentence not undermined when it cannot be carried out?
Because well, my lord, I appreciate this may be an abstract way of looking at it, but there is no attack on the nature of the sentence. It is simply that to carry out that sentence, on which there is no attack, after a period of 5 years, would amount to cruel punishment because of what has gone before. Now, that's not an attack directly on the sentence.
Right, thank you.
My lord, that's the only answer I can give, and it is, in my respectful submission, a distinction.
Yes, thank you.
Now, my lords, as to the appropriateness of a life sentence, the starting point in our submission is the mandatory nature of the death penalty, as I've already submitted. My lords, at risk of repeating myself, but just to make our position, I hope, as clear as I can, the Parliament of Trinidad and Tobago has determined that murder is so serious an offence that it carries a mandatory death penalty. That's the effect of Section 4 of the Offences Against the Person Act. In other words, as I've submitted, murder is so serious an offence that all murderers deserve to die. Next, the original sentence was and remains lawful, the point made by Lord Hughes in Lendor, and which I've sought to make. And I will be coming back to Lendor in two respects in due course. It follows in our submission that the only appropriate sentence the court can substitute in such a case is one which alleviates the prospective constitutional breach, the threat of execution, after the point is reached, when it would be unconstitutional to carry it out, but otherwise reflects the gravity of the offence and the legislative intent, and the two are two sides of the same coin. And that is achieved by imposing, we submit, the next most severe sentence that would mirror the gravity of the offence, in other words, life imprisonment. The Court of Appeal's approach, on the other hand, is, with the greatest of respect, inappropriate, we suggest, because its effect is to endorse the very thing which, notwithstanding the inconsistency between Section 4 of the OAPA and Section 5.2b of the Constitution, Matthew decided was not open to a sentencing court, namely consideration of individual circumstances of the offence or the offender. So, when exercising the power under Section 14 of the Constitution, it's impermissible in our submission to approach the case as a sentencing court would, requiring a consideration of all the usual considerations, because to do so would effectively be to treat the lawful mandatory sentence as distinct from the circumstances in which it is proposed to carry it out as unconstitutional. And, my Lord, that is the point I was making a moment ago in response to Lord Sales. That is the distinction in our submission. Because it is effectively to treat the lawful mandatory death sentence as distinct from the circumstances in which it's proposed to carry it out as unlawful or unconstitutional. Now, I said I'd come back to Lendor, and I must, of course, address some observations at paragraph 35 of Lendor, which are relied on by the respondent. Can I just take you back to Lendor, which is at, for my purposes, 772. The judgment starts at 758, and could I ask you to turn up 772? Can I start at paragraph 33, please, at the bottom? The question does not arise on the appeals of these appellants, but was addressed by the State in argument, and that's the powers of the High Court on a constitutional motion. Attention was invited to the proper course to be adopted if a constitutional motion were to be brought before the High Court by a prisoner who contended that he had been the victim of unreasonable delay within the principle of Pratt and Morgan. In particular, and this, my Lords, is important because this was the precise focus, in particular, the Board was invited to consider whether the presence of the presidential power of pardon in the Constitution meant that the Court should defer to it by leaving remission of the death sentence and substitution of an alternative sentence to the President. Section 14 of the Constitution gives the High Court very wide powers to ensure that a citizen is not deprived of his fundamental rights, and it's set out. And then at 35, subsection 3 there referred to applies to the State Liability Proceedings Act, and then picking up at 4 lines down, section 14.2 is for present purposes in terms identical to section 25.2 of the Constitution of Jamaica, which was the governing supreme law in Pratt and Morgan. In that case, the prisoners had brought constitutional motions under section 25. The Board entertained no doubt that the provisions of that section were amply wide enough to enable it not only to declare that execution after unreasonable delay would be unconstitutional, but also to substitute sentences of life imprisonment, see paragraph 78. It did so notwithstanding the presence in Jamaica of a power of pardon in terms essentially identical to those in place in Trinidad and Tobago. And that's addressing the precise point at the bottom of page 772. The Board sees no reason to depart from the view which it expressed in Pratt and Morgan. The very wide words of section 14.2 of the Constitution of Trinidad and Tobago empower the High Court, if on a constitutional motion it finds that the execution has become unlawful by reason of unreasonable delay, so to declare and to order commutation to an appropriate substitute sentence. The occasion for the High Court to do so may be relatively rare, if the practice of issuing a presidential pardon after the passage of 5 years is followed, as presently it appears to be. But if for any reason there has been no pardon at the time when the High Court determines an application under section 14, the Board can see no reason why the Court should feel constrained to confine itself to a declaration of unconstitutionality, together with any other relief, and should not proceed to substitute an alternative sentence. Now, my Lords, I of course recognise that based on what Lord Hughes said at the end of paragraph 35, the board in Lendor may have thought that a substitute sentence less than life imprisonment could be imposed by the court under section 14(2). And it's relied upon that one line in Lendor by my learned friends. As to that, we make 5 points. First, the question of what the court can do in a Pratt & Morgan case such as the present did not arise for determination in Lendor, and that's expressly acknowledged at the beginning of paragraph 33 of the judgment, and Lord Hughes' remarks were therefore with respect obiter. Secondly, the primary focus, as I've submitted of the remarks, was in response to an invitation that the board consider whether the presence of the presidential power of pardon in the Constitution meant that the court should defer to it. We see that from paragraph 33. Thirdly, and more generally, Lord Hughes' remarks were made in the context of considering the presidential exercise of the power of pardon, not the exercise of section 14 powers. And that presidential power is not confined in any way. Fourthly, as is clear from the judgment, Lord Hughes' remarks regarding the court's powers under section 14 were made without the benefit of full argument on the point. There clearly was some argument, but clearly not full argument on the point, and certainly without the benefit of the submissions that are made by the appellant in this appeal. And finally, fifthly, my lords, if despite those four considerations the board were to consider that Lord Hughes' remarks provide some support for the respondent's contention, they are, with the greatest of respect, wrong for the reasons we have already submitted. There is, however, one important respect in which the appellant relies on Lendor, and that is as to the nature of a life sentence in Trinidad and Tobago. My lord, the question you asked me rather a long time ago. The Court of Appeal, in this case's conclusion that a court should have the full range of sentencing powers available to it when exercising its power under section 14(2) appears to have been influenced by the court's view that a sentence of life imprisonment in Trinidad and Tobago is effectively irreducible. We see that from the Chief Justice's reference to various decisions of the European Court of Human Rights and the courts of Antigua and Barbuda at 84 to 85 of the electronic bundle. Concluding at paragraph 50 at page 86 with the remark, "We are cognizant of the fact that unlike our jurisdiction, Antigua and Barbuda and many of the European contracting states have legislation that provides for a review mechanism." And my lords, to the extent that the Court of Appeal considered a life sentence in Trinidad and Tobago either as not susceptible to review or irreducible, really two sides of the same coin, and potentially therefore a cruel and unusual punishment on that basis, with respect, the Court of Appeal was wrong, as we see from Lendor. So, my lords, in that respect, can I take you back to
But before leaving that, it does refer to legislation, and they're strictly accurate about that, insofar as it's in the prison rules and in the Constitution.
My lord, it does. Forgive me, I misunderstood perhaps the point that your lordship was making.
I mean, if one's parsing the judgment of the Court of Appeal, they're correct that there is no legislative review mechanism.
Well, my lord, in that respect, yes, but the thrust of what...
Do they say anywhere that the sentence of life imprisonment is irreducible in the judgment?
My lord, no, I don't think that they do. But certainly what I get from a reading of the European Court of Human Rights provisions, which are judgments which are, or penal philosophy, as it's put in paragraph 47, and what follows, and then the observations made in relation to Antigua and Barbuda are the sense that there is something about the death penalty, the life sentence in Trinidad and Tobago, which is irreducible. I mean, that is the sense I get from reading it. I may be wrong about that, but my lords, at any rate, it matters not, even if the Court of Appeal were not saying that. What matters in our respectful submission is what is the nature of the life sentence in Trinidad and Tobago. And for that, I was going to just take you back to Lendor, if I may, at paragraphs 45 and following, so page 776. My lords, perhaps rather than listening to me read rather a lot, could I invite the board to read paragraphs 45 to 49 on 776 and just over the page? So, my lords, could I then ask you just to turn to...
Sorry, just before we move on from that.
Yes.
I understand from paragraph 46 that the procedure for review by the prison authorities and then others leads to a mechanism which is the exercise of of presidential pardon under section 87 of the Constitution.
That is the mechanism by which early release can be achieved.
Yes. My question is such a pardon a full pardon, or can there be release on license?
Well, my lords, in terms of what the President can do in exercise of his powers, his powers are very wide indeed. So, presumably, yes, he could attach that sort of condition.
I see. All right.
But, my lords, can we just pick up on this a little bit further? On page 781, where Lord Hughes, under the heading irreducible life sentence, says a little bit more. The contention of the appellants is that life sentences, and equally the 75-year sentence, since they are de facto indefinite, are irreducible unless there exists, and then there are various contentions which the appellants there suggested were the indicia of a proper sentencing process. And then Page 782, I should just note between letters C and D, Lord Hughes notes the absence of a parole system in Trinidad and Tobago and says that release, if it is effected, is unconditional. So, my Lord, that is possibly an answer to your question, but equally, as I've submitted, the President's powers are such that he could potentially make release conditional on some basis or another. The decision not to inaugurate parole and license system may be in part attributable to the fact that systems are heavily resource intensive and so on. And then picking up at 65, the underlying principle of the Strasbourg cases may readily be accepted as applicable in Trinidad and Tobago. It is that however grave the crime, to imprison someone without any prospect of ever being released, no matter what change of circumstances there may be, is punishment which is cruel and unusual, and accordingly a breach of Section 5(2)b of the Constitution. Therefore, secondly, any such sentence must offer, in some form or another, the possibility of release. That, in turn, must mean, thirdly, that there must exist a system of review, for without it the prospect of release would be a matter merely of chance. And fourthly, if the decision to release or to continue to hold is not to be simply arbitrary, it must be based upon either pure mercy or an assessment of whether continued detention is justified or legitimate on legitimate grounds or not. And then there's a reference to Lord Bingham in Lishniak, observing in passing that release cannot be left to the chance of whether the executive does something. And then 66, conversely, the fact that a prisoner may well serve his whole life in prison does not by itself achieve the minimum level of severity required for breach of Section 5(2)b, nor does the necessity to avoid cruel and unusual punishment mandate the attachment to every life sentence of a minimum tariff term of the kind which is required in England and Wales and permissible to courts in Trinidad and Tobago under Section 69A. So under 69A, a judge imposing a life sentence in a case where that can be done can impose a tariff. And then, my lords, could I ask you finally to look at paragraph 73 and 74 on page 785. What should be drawn by way of instructive example from these decisions of the Court of Human Rights are the fundamental principles. It is apparent that the system of 4 yearly reviews, that's the Trinidad system, provides what is required, indeed considerably more regularly than is contemplated by the Strasbourg cases as the maximum necessary. The principal focus of the reviews is whether release should occur or not. It is neither practical nor consistent with the underlying principles to attempt to resolve the Strasbourg differences as to the manner in which the review should proceed, beyond the fact that, in addition, in an appropriate case to considering pure mercy, the advisory committee and the minister giving advice to the President must consider in broad terms whether all the circumstances of the case call for continued detention or not. That is all that is required to prevent the sentence failing to offer any prospect of release, and thus being characterized as illegitimately irreducible and thus cruel and unusual punishment. The need to avoid irreducibility is not to be converted into a draftsman's scheme for a system of public law. It is sufficiently clear that the present process avoids the sentence failing to offer any prospect of release. If, as Mr. Fitzgerald suggested, there might be occasions when the ultimate recommendation of the minister could be demonstrated to be based on irrelevant considerations, then judicial review is available to put the legal error right. There must also be sufficient due process, which will be achieved if the ruling of Raj Kumar J. set out at paragraph 47 is followed. For these reasons, as well as what has been said in paragraph 53 above, the Board concludes that the present sentences cannot be found to be unlawful as irreducible. Now, my lords, in summary, therefore, just putting Lendor to one side, in Trinidad and Tobago, life imprisonment is reducible in a number of ways. Section 87 of the Constitution enables the President to grant to any person convicted of an offence a pardon, either free or subject to lawful conditions. My lord, those are the terms of Section 87.
Which page is it?
My lord has that at...
Page 505.
I'm very grateful, my lord. Thank you.
Thank you.
yes.
Yes, thank you.
My Lord, I wasn't proposing to read it.
No, I just wanted the reference.
My Lords, a prisoner can himself petition the President for clemency. Next, Rules 281 and 282 of the prison rules, as you've seen from that review at paragraphs 45 to 49, provide for review and apply to punishments by commutation as well as to sentences imposed by the court. Now, those rules, for your Lordship's note, are at 519 of the electronic bundle, and that they apply to sentences imposed by commutation as well as sentences imposed by the courts is clear, or at any rate entirely implicit in Lendor in those paragraphs 45 to 49, and also from some cases or instances referred to in paragraph 53.
The rules are at 589, do you say?
I'm sorry, the rules are at 519. If I said 589, I was wrong, my Lord. 519.
My fault, sorry.
Thirdly, my Lords, the process of review is subject to the rules of natural justice and judicial review. And fourthly, moreover, the system of 4-yearly review which operates in Trinidad and Tobago not only provides what is required, according to the review of the authorities conducted by Lord Hughes, but in fact considerably more regular review than is contemplated by the Strasbourg cases as the minimum necessary.
Mr. Stevens, can you hear me?
My Lord, I can. I'm not sure where I should be looking, but I can hear you, my Lord.
Okay. If there's a minimum tariff specified as part of a life sentence, how does the review system work there, if at all?
Well, my Lord, the rules do not, or my perusal of them, provide for that. I don't think more is said than it can be done in section 69A, but I will check that. I presume
can you impose a determinate sentence with a minimum tariff?
Within the term of the minimum tariff, my Lord?
Yeah.
No, I don't think so, my Lord. I think one would have to interpret the review provisions as applying after expiry of the minimum tariff period. But I can't give your Lordship authority for that proposition. It is simply what must be, in my respectful submission, the logical result of being entitled to impose a tariff stipulating a minimum period that must be served on the one hand, and reviews which presumably therefore must kick in on expiry of that period on the other.
But that doesn't sit with the function of a pardoning system, which comes in after a sentence has been imposed. You couldn't exclude the presidential power of pardon by the court setting a minimum tariff.
No, not the presidential power of pardon, but release pursuant to the review mechanism under the prison rules wouldn't necessarily kick in. I entirely accept that. But, my Lords, we will endeavour to see whether there is direct authority on the point, but that would be my principled submission in response to your Lordship's question.
And Mr. Stevens, I think you said, is it section 69A contemplates the tariff?
Yes.
Again, if we just had the reference, that would be...
Yes, of course, my Lord.
It's section 69A what? I should know.
My Lord, if you just bear with me one moment.
Certainly.
The Interpretation Act.
I'm grateful, my Lord.
And which page number? I'm sorry.
My Lords, you don't have that in the bundle of authorities, but we'll make a copy available over the lunch adjournment.
Thank you.
Thank you.
Now, my Lords...
I wonder if that's a convenient...
Oh, I'm so sorry. Time has crept up on me, my Lord. Yes, it is.
Good. Well, we'll rise now and we'll sit again at 2 o'clock. Thank you very much.